Crypto startup LBRY violated securities laws by selling its native LBC tokens without registering with the U.S. Securities and Exchange Commission. That is, according to New Hampshire Judge Paul Barbadoro. Now, the SEC sued LBRY back in March of last year, claiming that LBC tokens were securities and that the startup had violated securities laws by selling them without registering with the agency first. Now, so what's next for LBRY and consequently Ripple and the XRPArmy? Stay tuned. This is Money Talk Sundayz midweek edition. Welcome to Money Talk Sundayz. I'm your host, Stevie B. First and foremost, I want to apologize for the last couple videos that were uploaded. The last couple episodes of the Money Talk Sundayz, there were some sound issues that has swiftly been addressed and resolved. So let's trust and believe we're good to go here on out. Now, for those tuning in via your favorite streaming platform, hit that like and share button. You can also subscribe to the Money Talk Sundayz podcast. The link will be right there in the description box. For those that's watching on YouTube, like, share, subscribe, hit that notification bell. You might receive an email, so some kind of notification when the next time the video drops. Maybe, there's a whole lot of thing about YouTube going on right now, but whatever. Anyway, as I mentioned during the opening, the SEC sued LBRY over their LBC tokens, claiming they were being sold without being registered with the agency first. Now, LBRY countered, saying that their tokens were not securities and that the SEC did not give it fair notice that its sale of the LBC tokens was subject to securities laws, thus violating the company's right to due process. Now, the judge overseeing the lawsuit, Barbadoro, the district court for the District of New Hampshire, ruled Monday that no reasonable trier of fact could reject the SEC's contention that LBRY offered LBC as a security, and LBRY does not have a triable defense that it lacked fair notice. Now, after the ruling, LBRY took to Twitter, tweeting, "We lost. Sorry, everyone. We're going to lick our wounds for a little bit, but we're not giving up." Now, LBRY founder Jeremy Kauffman stated that the SEC versus LBRY case establishes a precedent that threatens the entire U.S. cryptocurrency industry. Now, under the SEC versus LBRY standard, almost every cryptocurrency, including Ethereum and Doge, are securities. The future of cryptocurrency in the U.S. now rests with an organization even worse than the SEC, the United States Congress, which is why Kauffman is running for Congress, so there could be crypto-friendly people in Congress to allow blockchain. Now, this ruling, as we know, can have wide-ranging implications on the crypto industry as a whole. Notably, Ripple Labs is in a heated contest of their own with the SEC. Ripple Labs and two of its executives have been charged with selling over $1.3 billion in unregistered securities. Much like LBRY, Ripple Labs' defense has hinged on its claim that its native token, XRP, is not a security, and that by failing to provide clarity on whether XRP was a security, the SEC did not provide fair notice that Ripple Labs' conduct was unlawful. One moment. Now, as the time for summary judgment is approaching fast, the XRPArmy appears to be pretty confident of the lawsuit turning in favor of their company. Now, according to Andrew Rosso, an attorney and adjunct law professor, the court's ruling in the SEC versus the LBRY case use the Howey test, a test which helps to define what is and what isn't a security in the United States. Now, per Rosso, although the test was used, it did miss a key mark in the area, missed the mark in the key area. The court missed the mark in identifying a distinction that possibly speaks to a further clarification of what a reasonable expectation of profits means under Howey, as it applies to projects such as LBRY. That distinction separates what I believe to be LBRY's recognition that it is a work in progress, and while it does want to see its investors make a return on their investment, that the only way that will happen is if others believe the project to have the utility as the company has presented it. Now, this same test was applied in the Ripple lawsuit. Attorney Johnny Deaton said that the LBRY's lawyers did not challenge Howie's second-pronged test, which required a common enterprise. Meanwhile, in the Ripple case, the common enterprise was challenged. Further, the expert witness for SEC argued the common enterprise is the entire Ripple ecosystem, including the exchanges, the vendors, merchants, retail holders, etc., etc., etc. Now, the XRPArmy, to counter that, submitted more than 3,000 affidavits to prove them wrong, due to which the expert witness for the SEC was abandoned. Now, John Deaton concludes by saying the SEC may make a big deal about this victory against LBRY in the Ripple case as well. Now, the judge's ruling on Monday means that the LBRY case will not actually go to trial. Instead, a status hearing to determine next steps has been scheduled for November 21st. Now, this has wide-ranging implications, as we already said, with the whole crypto industry. Doge is hurt, Shiba Inu's hurt, Ethereum's down, XRP fell a few cents just off of this news. It's sub 46 as of the time of this writing. Look, they are fearful, they're scared, they're paying attention to what's going on in these courts, what these judges are saying, how the SEC is moving. But people are confident, particularly XRPArmy is confident that in the Ripple case, they will still come out with a W. However, that is looking a little bit cloudier at this point. There needs to be some clear lines put in the sand as to what's going to be what's going to be defined as what, so people and companies and investors know how to move going forward. Well, anyway, that's all I have for you today. This was just a quick midweek episode, little jump in after I got the news about the SEC versus the LBRY case. I decided I wanted to speak on that and its relation to Ripple and how Ripple is moving as well. If you have any more information, I know we're all still waiting for that outcome of the SEC versus Ripple Labs. I'm definitely waiting, and I definitely have some investment in Ripple and XRP, waiting on the outcome of that. But other than that, that's all I have for you today. Happy trading, everyone, and see y'all this Sunday for our Money Talk Sundayz episode. I'm your boy Stevie B. I'm out.